Well, so
Until
the
it's official.
contract, I don't have them sign until their personal representative.
What if you don't think it would be I mean, just to cover yourself, it wouldn't be a good idea to try, let's say there's a buyer interested and they wanna go ahead and at least try to solidify a deal until that's done. It's not a good idea to at least go in there as proposed.
Like a short sale that
Yeah.
starts when?
TBD.
No,
Yeah.
or the effective date starts when?
I
Yeah.
think
The
I don't
calendar
think
for
so here's the real reason behind there's two reasons why you don't want John signing stuff is one, you want to protect him, okay? Because John, let's say you do that, you sign a contract and John is not personal representative and he just signs it as John Smith. Maybe proposed is okay, but he signs it as John Smith. Well, let's say for whatever reason the deal goes south, buyer's pissed off. Instead of suing the estate, he could sue John individually because John's the one who signed the contract. You want him to be personal representative to protect him. So that's number one. Number two, I don't know if it would clear with title if the contract just said we would change it later.
No,
we would change
right.
we would
I
change
know
it.
it wouldn't clear with title.
Yeah.
But at least in the meantime.
Yeah.
That's.
Um,
But that's, you
Yeah,
brought up a
and
valid
maybe-
point. You brought up a valid point. It's something that I always tell the agents. Like,
Yeah.
You know, you have to think if something were to happen, we have to have all our ducks in a row.
right. So what I
Don't
know.
get upset at me. but
Yeah,
it's-
yeah. It's frustrating because you do all this work, you got the listing, you want to get them under contract. I definitely get that. I normally say get the listing agreement, sign it as proposed personal representative. Then once we get him appointed as personal representative, list it. Because the problem is you can't list it until he's personal. I mean, maybe you just get one off the streets and you know somebody.
Well, you can disclose.
Yeah, I would. You're the boss here. I was my opinion would be wait till you have wait till you have the personal representative and before listing it or before signing any contract. What you could maybe as an option, what you could do is if you sign it as proposed in that extra area where you put additional language, you could say, I always say subject to court approval anyways because the court's got to approve the sale, and then you just could say subject to personal representative being appointed or something like that. But so those are the two areas where I see most for realtors as very important. Don't just go sign up, because you think he or she's going to be personal representative. At least put that proposed language in there. Make sure you put that personal representative language in there, and then I would say probably wait or have that language, conditional language, until the personal representative is appointed.
I need to chime in on something.
Yeah,
So,
sure.
If you come across that situation, what Justin's saying is not to lose the opportunity.
Yeah, definitely not.
That's the reason why he's saying this. So there's a form that would go along with that listing agreement because we have a responsibility to do what? Enter that listing into the market within a reasonable time period. So we're not going to be doing that in this case if we have a proposed personal representative. So you have that personal representative sign the opt-out form. Does everyone know what the opt-out form is?
No.
No? Anybody do know? Does anybody know? Great. Great.
Another class.
Listen up. Listen up. The opt-out form is something you must use. You must use this if you're not going to enter the listing until much later on from the listing signing, the signing of that listing contract. It's an opt-out form. It's one of the AOR forms, and you can find it and then just bring it, print it along, or put it on dot loop, and have the seller sign that opt-out form. You determine a date that you're going to hold on to publicize that listing. Determine that date, and that's what's entered. That opt-out form is an instrument that will protect you for not listing the property publicly, but having a listing contract.
And can
Everybody
it be,
understand
and
that?
the date can be changed, extended?
The date can be extended, the date can be changed, but you must have a listing agreement with the opt-out form. So please, please, please do not send us a listing contract that's gonna be put on the market in 2 weeks or 3 weeks without an opt-out form, because we'll get a violation. Later on, if we have an entry date of the listing and if we have a signed contract, there's a huge difference if they audit us, we'll get fined. So you'll get fined.
Even if,
Everything we do is to protect you.
Yeah.
It's not to be your enemy. It's to protect you.
but
Go ahead.
just on that, so if you have like a listing agreement signed today, but you decided to list it a month from now, you
You
still
don't
need it?
decide.
No, but I mean, if they
Yeah,
just for
you know.
whatever reason didn't, you still
Right.
need it, even
You
though the
still
listing
need it.
agreement says it's gonna be
Listen,
listed
the
on
paint in the house.
If you,
A
if
month
the
from now?
signature's gonna have today's
today's
date,
date, you still need it?
and if the signature's gonna have today's date, but the listing contract starts,
On a month from today?
no, that's fine.
Okay.
But if you have the listing contracts dated
Signed
today,
today and dated today, then-
today is also the date, then you need an opt-out.
Okay.
Okay, good stuff.
24 hours.
Okay, so then let me
Sorry.
No, that's
I
good
had to
stuff.
say it.
Good stuff. No.
Activities.
All right. So how long? So, two questions probably that they're going to ask you most likely, and that you want to know: how long does it take? How much does it cost? Right. So those are probably the two biggest questions. So let me talk about time first. So there's two. I'm going to try to give you two timelines, and if you sign that sheet, I have timelines that I can send you. So wherever that sign-in sheet is, if you would keep that going, so I can send you that information as well. But so two timelines. So the first timeline is probate can go a little bit faster. Is if the person died over 2 years ago from when we opened the probate. Okay, so that's the first key distinction. So let's say we opened the probate in 2019 and the person died in 2016. So over 2 years ago. Is everyone with me? Okay, so if they died over 2 years ago, like I said earlier, it usually takes, on average, again, this is, take it with a grain of salt, but on average, it takes about 3 to 4 weeks from the date the client hires us, we prepare the documents, we file it with the case or file with the court to get a personal representative appointed. So about 3 to 4 weeks, okay? At that point, you guys can sell the property, list it, sell it, all of that. Once you get a contract, we're going to take that contract, present it to the judge to approve the sale. Again, on average, it's probably going to take about 2 to 4 weeks to get approval. Once we have approval, you guys are done. You get paid, title closes. So if the person died over 2 years ago, on average, it's about a 2-month process, more or less. Could be a little bit longer, could be a little bit, obviously, if maybe not so obviously, but if you have, we've got one now where we have siblings in Israel who don't want to sell, and it's just, it's a mess. So sometimes that type of stuff like that does happen, and that can definitely make it go longer. Or if you've got 2 wills where sister has a will, brother has a will, and we're fighting over which one's real. Mom was sick. Someone's saying she had Alzheimer's when she signed the will. I mean, everything can happen. So sometimes it can get messy. But on average, if everything is just smooth and 2 to 3 months, if they died over 2 years ago. If they died within 2 years, so let's say they died in 2018, we opened the probate in 2019. So again, about 3 to 4 weeks to have the personal representative appointed. Then we have a 3-month, what I call waiting period, and it's called a creditor period. So month 1, we got the personal representative appointed. Month 2, we're waiting. Month 3, we're waiting. Month 4, we're waiting. And then in month 5, you all can sell the property. Okay? So here's the reason for that 3-month period. Again, this is just the law. There's a 3-month period after the personal representative has been appointed where any creditors are going to come and send us saying, Baptist Health, John owed us money when he died. American Express, John owed us money when he died. And we have to wait for that period to expire because after 3 months, doesn't matter if anyone's owed money, they have a 3-month window and that's it. And so most courts, most judges won't allow you to sell the property during that 3-month window. Some will. But sometimes what we'll do to get around that is, let's say this is a property, it's in foreclosure, or the family doesn't have there's a mortgage on it, the family doesn't have the money to keep paying the mortgage. We'll go to the judge during that window and say, Judge, look, if they don't sell this property, they're going to lose it. We need to sell it. And again, I don't want to say always, but usually the judge will allow us, and he'll just let us put that money into essentially what is an escrow account until that end of the 3 months is up, and then the property, then we release the money. You all would have already gotten paid. You don't have to wait for your fees. I know people, that's the important part, right? So, you don't have to wait for your money, but to actually for us to release the money to the sellers or the beneficiaries, we might have to wait that window. So if they died within 2 years, it's probably gonna be more like 5 or 6 months. It could be a little, again, we could ask the judge to sell it during that 3-month window, but just on average we've done well over 200 at this point, ones that we've done, it's usually on average about 5 to 6 months for the sale. Good question. And then, cost, I get asked this a lot. So, some attorneys charge by the hour, some attorneys charge a percentage of the estate, some attorneys charge a flat fee. Generally, that's what we do. We charge a flat fee for our services. I would say on the low end, probably for standard probate, no fighting, no anything like that, you're probably looking at $3,500, $3,000 on the higher end, probably $9,000 or $10,000, somewhere within that range. So that's more or less on cost. And then real quickly, so finding probate properties. One suggestion I always just kind of leave realtors with is Miami-Dade is really cool in the sense that if you go to this website, the Miami-Dade Property Appraiser website, and you put in to the owner, how you can search for by owner. If you put in the owner, you put estate of, so ESTATE space OF, you're gonna get a list of, not all, but a fair amount of properties that are owned by estates. And so you could, in theory, create a mailer, a direct mailer that maybe goes to the property and says, hey, listen, I'm a realtor, I work with probate. You might not know this property needs to go through probate. We can help you, that sort of thing. So that's a way that I don't think a lot of realtors, I know a lot of realtors don't do that, but I think it's kind of I wouldn't say secret because I tell a lot of people, but it's a good way to get listings that other people might not get.
I didn't know that.
Yeah.
I did not know that.